Morning, Mr. Mokhesi.
Morning, Advocate.
We were at bundle FS 14 at page 129, and we were about to deal with the conclusion of the so-called session agreements, material supply session agreements. But I wanted to deal with something before that is not dealt with to any extent, at least in your affidavit. In paragraph 92.1,
in paragraph 19,
92.1 at page 127 of FS 14, you describe the difference between the building contracts and the material supply agreements, and you explained how the material supply agreements amended or altered the building contract agreements and the regime that was set up in terms of those agreements. Do you recall that evidence?
Yes.
what was the answer, Mr.?
Yes, it was yes.
Yeah, okay.
Right. And then, if one goes, in describing those agreements, your affidavit does say that it's not clear how the parties who entered into the material supply agreements were identified. In other words, who selected the suppliers. You recall that evidence?
Yes.
Was any investigation done, under your watch at least, to find out how the individual suppliers were appointed?
No. No. It wasn't. It wasn't done to that extent. But it was very clear that they were selected arbitrarily because some of the material suppliers are genuine material suppliers, like your Coro Break and so on.
Yes.
That I know. But others, I mean, there's one that I think I can recall. That is also in the affidavit where we made an example. Who was a supplier of material. I think it's Pearl Construction, if I'm not mistaken. He was a supplier of material. He was also a contractor and also subcontracted in certain instances. So there were those type of, and obviously that type of arrangement will ordinarily become very expensive, particularly to the contractors that are linked to.
Yes, because the contractor had to produce the building ultimately, or the buildings at a set price.
Yes, the contractor had, the price was fixed. Indeed, yes, correct.
Yes, and we know that subject to individual investigations, and we know that there are some examples produced by those investigations that show that there were suppliers who did not act properly or honestly, and suppliers who should not have been appointed in the first place. Is that correct?
Correct.
Now, one would have thought that in those circumstances, one would have asked the question, who appointed these suppliers and why were these particular suppliers appointed? I'm not talking about the genuine suppliers like Corobrick and others.
Yeah. Look, let me say for my side, I never got a clear answer as to who supplied, who selected in the first instance, and what was the criteria that was used. Hence, the the investigation and ultimately the disciplinary process that went on, because the people involved did not come out very clear as to how the contractors were appointed, who selected, how they were selected, and so on. So that information never came out.
So that problem arose both in respect of the contractors and in respect of the suppliers. And you say that full information could not be obtained in regard to the manner in which they were selected.
Yes.
I'd like to put to you some passages in that regard from the disciplinary inquiry. If you would just reach behind you, please, and get bundle FS12. That's the statement bundle. This is the affidavit of Mr Mcquino. Remind us, please, Mr Mcquino was who?
Mr. Mcquino was the HOD, the head of the department there.
During 2010-2011?
Yes.
Correct. You would go to page 344, please, of that bundle. Yes.
Yes, I'm in 344.
In his affidavit, which we will deal with hopefully later today, Mr. Mokoena is dealing with the implementation of the prepayment plan at page 344. You have that at the top of page 344.
Yes, I have that.
He says, it should be borne in mind that at that stage we were reaching the end of the year and the contractors were due to close on 15 December for the annual builders' holiday. He then says in paragraph 20, that's Mr. Mokoena, shortly after my meeting with the MEC at that stage you've told us was Mr. Zwane, correct?
Yes.
In paragraph 20, Mr. Mokoena says, shortly after my meeting with the MEC, he approached me with a list of about 106 contractors and instructed me to appoint these contractors. Did you establish that fact in your own investigations?
Well, no, I didn't, because as you can see, this was a meeting between two people, if it happened. And that information, if indeed it was so, I would have got it from the officials at that time, but they were not forthcoming in terms of how
you said they weren't forthcoming.
They were not forthcoming in terms of how the contractors was. We know that it was cancelled, the bid was cancelled, but the criteria that was used in terms of appointing those contractors they were not forthcoming.
Right.
Mr. Mokhesi, you say the officials were not forthcoming, but you knew who was the HOD at the time. Did you not ask the HOD, even if he was out of the department?
Well, he never told me.
No, he wouldn't tell you if you didn't ask him. Did you ask him?
No, I didn't.
Why not? He was the HOD. He was in charge of the department. You wanted to know how these contractors got appointed. Why didn't you ask him? He was the most obvious person to ask. Why didn't you write to him? Why didn't you phone him and say, Mr. Mokoena, You were HOD when this mess happened. Who selected these people? Why did you limit your inquiries to junior officials when you knew who was the HOD at the time?
My question were to the people who were at that time involved, who were the officials, the senior officials in the department, who were part of that.
Do you mean you took a conscious decision not to ask the person who was HOD?
I couldn't say I took a conscious decision. I did not ask, Chairperson.
Yes.
I did not take a conscious decision.
Yes, but why did you not ask the most obvious person, namely the HOD at the time? Because the fact that he might not have been in the department didn't mean you could not ask him. It didn't mean you could not phone him. It didn't mean you could not direct a letter to him to say, I want to know who made this decision, because you were
and we have appointed these contractors and so on. So that's basically where it ended. And then I started to say, okay, maybe let's institute an investigation to find out exactly what happened.
Well, we'll see when all the evidence is in, Mr. Mokhesi, but I'm just surprised. One gets the impression that whatever investigation was being done within the department wasn't done with the vigor that one would have expected when so much of taxpayers' money seems to have been lost.
I was not the only person who was doing the investigation.
Sorry?
Also, I was not the only person who was doing the investigation. At that
Yes,
time, at that time as well, an investigation had already been proclaimed. When I went into the department, the investigation, the president has already proclaimed on that. The investigation was ongoing anyway.
But
Now,
if you could ask, Mr. Mokhesi, if you could ask the junior officials, why couldn't you ask the HOD of the time? The fact that there was an ongoing investigation didn't prevent you from asking the junior officials. Why did it prevent you from asking the HOD?
You see, Chairperson, when I arrived, there was already an issue or a complaint, a letter directed to me. The first day when I reported to work, the SIU there was already a letter on my table that says officials are not cooperating, including the head of the department. Earlier, there had been a letter that was written to the HOD then to say, please, this information, and it was followed up by myself. So if there is a point where they say the SIU themselves, who had already started, that there was no cooperation, they have written to the HOD already, and they were not getting joy. Surely, that was sufficient reason for me enough to be able to say, right, let me just try and source that information, whatever information that SIU has requested at that particular time. And this is exactly what I did. Because already before, the SIU has indicated that they had written to the HOD and around requests of this type of information and so on, and it was not forthcoming.
Was it only the previous HOD that the SIU said was not cooperating? Or did it also say the same thing about some of the officials?
They indicated that they had written to the HOD and the officials concerned. So that letter is there.
But you see, you are saying to me that letter from the SIU gave you justification for not asking the previous HOD. But from what you are saying, the SIU letter also said the officials were also not cooperating. But you did ask the officials, but you didn't ask the HOD. Yes, Mr. Pretorius.
Apologies, Chair. We will deal with further allegations in this regard in the affidavits and in the disciplinary inquiry in due course. But what is striking, Ms. Mokhesi, that there was a disciplinary inquiry conducted against certain officials, the more junior officials. The transcript of that inquiry runs into almost 3,000 pages of finely packed detail. There was a thorough investigation in regard to certain people, but it seems in regard to others, there was no investigation at all. And the inference that is drawn is that certain people were being protected.
Mr. Pretorius, I don't know about that. I don't know whether there are certain people who were protected. I simply, because, you know, the result of the investigation and so on, you know, the disciplinary hearing was the outcome of the investigation to say specific people. I mean, that's what they put it out to, and that's why there were those people who were charged. Because I can't, at where I am, say that there were certain people who were protected, because mostly I was never, you know, deliberately so, to just to keep away from the investigation as it was done, both by the SIU as well as the one that was instituted against officials. Because some of the officials were only got away with a warning. Not everybody was dismissed in the process. There are officials who were also charged, but they received a warning. There were others who were dismissed on the recommendations. So to say that there were others who were protected, honestly, I'm not in a position.
Well, we'll come to that in more detail in due course, perhaps not in your evidence, but in the evidence of other witnesses as well. But does it not strike you as strange that we have a disciplinary record of nearly 3,000 pages of questions arising out of a very thorough and very detailed investigation on the one hand, and then in respect of certain persons, questions simply just aren't asked? Is that not a strange situation?
Which persons?
Well, we know that no questions were asked about how the 106 contractors were appointed, by you certainly. You see, the point I'm making is that certain people were picked for discipline. That's another question, how those names were arrived at, but I'm not going there for the moment. Certain people were charged pursuant, and the inquiry was held pursuant to a hugely detailed set of investigations. Investigations that took 3,000 pages to lay out and traverse in the disciplinary inquiry, and then there were disciplinary inquiry findings. And I will deal with those findings in due course, because one of the defenses raised by those persons was we were following orders and implementing decisions by others. Notwithstanding that defense, they were still found guilty and they lost their jobs, and some still are unemployed. That is on the one hand. On the other hand, in relation to who made the decision and how the decision was made to select the contractors once the procurement processes had been abandoned, it appears that no investigation has been done, at least that you know of.
Okay.
I want to add this, Mr. Mokhesi. I go back to an issue I raised with you yesterday. Well, at some stage I was saying, I got the impression you were, or you didn't want to be categorical on certain issues, but you were not in a position to tell me yesterday as to how many houses had been built by the end of the financial year, how many houses had been built by the time, by October 2010, and yet we are in 2020. If you were really interested to establish certain important facts about this, I don't understand why, knowing that you were going to come and give evidence about this, you would not know that. To say the department paid so much money, but there were only 100 houses that had been built to completion. X number of houses were only built up to the wall. So many, it was only the foundation. And when you look at all of that, it could not have cost more than this. Therefore, so much money was just wasted. I couldn't understand why you couldn't have that information at hand.
Chair, with due respect, this thing happened, and when I come here, I don't know the questions that I'm going to. You prepare for some, others you don't. But I think yesterday what you have instructed me to do, requested me, was to get that information, which I said we should be in the position to get it by going back into the system. That I said we will do. Now I'm under oath here. You know, I can't. The most dangerous thing is for me to speculate and find out that it isn't actually correct. I'm under oath.
No. I accept that you shouldn't say anything you are not sure about. And you shouldn't say you are sure. But what I'm saying is, when you come to give evidence here as head of the department about this project, it seems to me that you don't need to be told what questions you are going to be asked to know that you should be able to say, you know, Chairperson, this whole project, this is how many housing units they had been built by end of the financial year. This is how far they had gone by that time. Maybe the one about October might be shaky for me to expect you to know that, but at least by the end of the financial year, I would expect you to be able to say, to check that at least, you know. But you undertook to give us that information.
I did.
Yeah. Okay.
I did to say I will try and get that information. It is probably also available on the annual reports and so on and so on. You know, the number of annual reports that are there, as well as the 5-year plan.
Yeah.
Because I think what I will also indicate is that because of that particular issue, it became very difficult to catch up in terms of the targets, of the 5-year targets that had been set for 5 years, because there was no new money. So this issue of non-achievement in that particular year obviously will affect that. So I had said, you know, with those particulars, because it's about numbers, how many, and so on and so on. And I've said I undertook that I will provide that information.
Okay, all right, Mr. Pretorius.
Thank you, Mr. Mokhesi, for that. You will understand that part of the submissions that the legal team will make at the conclusion of this evidence will deal with the issue of accountability. In other words, who was called to account for what happened, not under your watch, but before you came to the department. And so it's only fair that these questions be put to you, even though you weren't there at the time. You were there at the time that accountability or non-accountability occurred. I want to just
I've
take
said
you...
so, Mr.
I'm sorry?
I said I've earlier yesterday I said you account for those things that happen even before your time.
Yes.
So that I appreciate and understand.
Well, you did say that, Mr. Mokhesi, to be fair to you, and it's in accordance with my expectation that a new accounting officer wouldn't just look at what happened when he or she came in, but would look at what had happened before, because the duty to rectify whatever mess happened before would be on him or her. So when you say you account even for that, it's in line with what I would expect. Namely, you come in, you want to see what is the state of the department. You see what has happened, you see what has gone wrong, you devise a way of rectifying those things, even though they happened before your time. So I'm just saying, to be fair to you, you made that point yesterday, and it's in line with my expectation of what a new accounting officer would do. Okay.
Do you know, for example, from your own investigations, Mr. Mokhesi, who devised the prepayment plan? Whose idea was it in the first place?
Well, when I look at the memos or documents that were there, there was a memo from particularly the one that was signed by 3 officials, Mr. Nthimotse, I think.
Sorry, by?
Mr. Nthimotse, the one that we discussed.
Nthimotse, yes.
Yes, because it looks like it originated from that particular.
From Mr. Nthimotse.
From that memo, which was signed and approved.
Yes, but he wrote that memo on instructions. Do you know that?
Well, I don't know on whose instructions.
All right.
On
Well,
whose
that's the
instructions?
question. Do you
No, I
know
don't.
where the plan originated? Who was responsible for the devising of the plan? You know that?
Well, I think the commission has called all the people to come and account here.
No.
So say on whose instructions, what I know is that it originated from that memo. And if Mr. Nthimotse says it was, he was instructed, then he must say by who.
Yes.
Because
Now,
there is an HOD
all I'm
as well.
asking you, I'm sorry I interrupted you.
Okay.
Did you finish?
Yes.
All I'm asking, Mr. Mokhesi, is do you know from your own investigations who devised the plan? That's all I'm asking.
You say, Mr. Pretorius, it was devised, Mr. Nthimotse got instructions.
Mr. Mokhesi, the question is a simple one. Do you have knowledge as to who
I
devised
don't have
the plan?
knowledge of that.
You don't have knowledge? You don't?
I don't have knowledge
Okay.
of that.
All right, well, let's go back, please, to page 344 of FS12 at paragraph 20.
Is it the same?
That's Mr. Mcquino's
Okay.
affidavit. And towards the end of 2010 is the period we're dealing with here. He talks of a meeting with the MEC, and he says that the MEC approached me with a list of about 106 contractors and instructed me to use appoint these contractors. He continues, although I cannot recall all the names on the list, I remember noticing that the first 6 contractors on the list were not contractors ever used by HS, that is Human Settlements, before. I also remember asking the MEC why we were allocating so many units, houses, to contractors that we do not even know. The MEC was, however, adamant that these were the contractors we should use. He continues, In relation to the 6 contractors mentioned above, I recall the names of 3 contractors, Alatori, Mokoena Property Developers, and Relato Properties. It should be noted that these contractors were very close to Mr. Zwane. I say this as Mr. Zwane personally called me to expedite the processing of their payments. Was any investigation done under your watch in relation to allegations such as those?
Chairperson, you know, if somebody asks you to do something that is irregular or unlawful or whatever the case might be, and because this is the discussions, this is what is an allegation between the accounting officer then to say this is how I was instructed and so on. The first thing that you do is you write that down. Now,
First thing you do is?
You're right to the authority.
Yes.
To
Who's
say,
giving instruction?
To say who gave the instruction, if you indeed you believe that this instruction is
Unlawful.
unlawful, the first thing that you do, you write to the authority, to that authority that instructed you to say this and that because of the following reason and X1. You either do that under objection, whatever the case might be, or you simply don't do it. Now I can't answer for Mr. Mokoena on the allegations and also around the investigation. What am I going to achieve? Because it's a discussion between 2 people who says he said that and so on. The fact of the matter is, this is what he says. What did he do? And I'm informed that he's also going to come and testify here around that. Then you'll have to answer that.
Yes, and he will be asked these questions. Yes. You can rest assured, yes. Mr. Mokhesi, but the question I'm asking is also not a difficult one. Did you, under your watch, conduct any investigations into allegations of this nature?
I don't know this actually happened. Remember, you're placing this affidavit now in front of me.
Yes.
I'm sorry, Mr. President, I didn't hear that.
I'm saying I don't know whether this happened. This affidavit is being placed in front of me now.
You have never seen it before?
I've never seen it before. It has not been given to me.
Okay.
Now, the point I'm putting to you is there is evidence that we know of and that the investigators have unearthed in relation to the question as to who devised the plan and who selected the contractors that became part of the plan, right? Now, all I'm asking you, were those investigations or were similar investigations ever conducted by yourself or by other people under your instructions when you were HOD? That's all I'm asking.
About this?
About 2 questions. Who selected the contractors that were to get contracts from the panel of contractors or the database of contractors? And how was the plan devised and by whom was the prepayment plan devised? Those 2 questions.
The source of the prepaid plan comes from the memos. The memo that was written by.
Did you ever ask?
I'm sorry, Mr. Mokhesi. Just take it easy. Listen to the questions carefully and answer them to the best of your ability. The question is simply whether you or somebody else under your instructions ever conducted investigations into those 2 questions. So it's either you say, yes, I did conduct the investigation, or yes, but I didn't conduct it myself. I instructed somebody to conduct it into those questions, or no, there were no such investigations that I conducted or I instructed anybody to conduct. That's what Mr. Pretorius is asking. were there in, let's break the question into two. Did you yourself conduct any investigations into the two questions he has raised?
Personally, no. I asked that the whole thing must be investigated. I was not specific to say investigate that, investigate that. So
You asked
I asked that the entire
investigation
prepayments or material advances
be investigated.
be investigated.
Okay.
I was not specific.
No specific
in terms of,
questions.
the terms of reference were there, were
Yes.
given, and and to say investigate this and come up with actually what happened.
Okay, Mr. Pretorius?
Well, that might assist us, Mr. Mokhesi. Is there a document which contains those terms of reference for the investigation under your watch?
I will try and get that.
Thank you. That would help us.
Yeah.
In any event, if we go back to page 344 of FS12 at the bottom of the page, the last paragraph, if I can just place it on record again and then go over the page, in relation to the 6 contractors mentioned above.
Last paragraph.
Yes. Well, I'm sorry to do
okay,
this, but
sorry.
it's important that it be placed in context because I want to put a long passage to you. Mr. Mokoena says in paragraph 20 on page 344 of FS12, although I cannot recall all the names on the list, I remember noticing that the first 6 contractors on the list were not contractors ever used by HS before. I also remember asking the MEC why we were allocating so many units houses to contractors that we do not even know. The MEC was, however, adamant that these were the contractors we should use. In relation to the 6 contractors mentioned above, and I've put their names on record, it should be noticed or noted that these contractors were very close to Mr. Zwane. I say this as Mr. Zwane personally called me to expedite the processing of their payments. Now, we will ask Mr. Mokoena about how he came to that conclusion. You can rest assured that we will do that. But he goes on and he says, I found this to be highly irregular, as an MEC in the normal course of business does not have any involvement in payments to contractors. And I suppose the same would apply to the appointment of contractors. Would you agree with that?
Yes.
Yes. Paragraph 21 on page 345 reads, as a result of the instructions given by the MEC, we as a department also did not go out on tender in order to appoint the contractors. The contractors were appointed as per the instruction of the MEC. So it seems, Mr. Mokhesi, that the HOD at the time was of the view that the contractors were appointed on the instructions of the MEC. It seems now that that was known to the HOD at the time. Do you see that?
Paragraph 21.
Yes.
Okay. Yes, I see that.
He goes on to say, within human
Mr.
settlements, we
Pretorius.
used to work on a system whereby we graded our contractors in terms of competency / performance. Therefore, we made sure that those contractors who always delivered on their contracts were the ones that received the big allocations for the construction of houses. This did not happen in relation to the appointment of these unknown contractors. To provide some context, it just does not make sense to award a contract to a contractor to construct 600 RDP houses if that contractor has never constructed an RDP house in his life. The latter is, however, exactly what we ended up doing based on the instruction of the MEC. We, for instance, allocated between 500 and 600 units / houses to the first 6 contractors that appeared on the MEC's list. At that stage, the units RDP houses were constructed for an amount of about 55,000 rand.
Mr. Pretorius, I think there is something wrong maybe with the, well, the aircon is not making any noise, but you can't hear me sometimes when I call you. So maybe I have to speak louder.
Well, I heard that.
But, no, I wanted to say, you were saying that Mr. Mokoena was of the view that the MEC had instructed, but I wanted to say, he doesn't say he was of the view, he clearly says he wasn't, they were instructed by the MEC. Yes, I just wanted to correct that.
Yes,
that Mr.
that's
Mokoena
correct,
is quite
Chair. Perhaps I wasn't
explicit.
clear what I
Yes.
mean. He's saying now,
Yeah,
in the course of the investigations, that happened in the past.
yes, yeah,
So that's his current
yeah,
view of what happened in the past. Thank you, Chair.
yes.
Mr. Mokhesi, the simple point I want to make is this is precisely the sort of issue that one would have expected to be the subject of thorough investigation after the event. Would you agree with that?
Yeah, remember, Chair, I think in the disciplinary hearing, Mr. Mokoena was called. I don't know, he was called also to come in and explain. Now, if you know, I can only discipline people who are reporting to me. I can't discipline people who I can't discipline my boss, so to speak. Now, if people are saying I was instructed to do X, Y, Z, and there's no written communication that will also even suggest that indeed that did happen, it becomes very difficult. Because we are talking about the meeting of two people somewhere. He says that, and I said that.
But you at least, shouldn't you at least take steps to establish whether what version you are told by the person who is alleged to have given the instructions, and then see whether in your mind you have any doubt about which version is true? Shouldn't you take at least that step? Because if you get both versions and you happen to think that you believe the version of the one who says he was instructed, you may want to take certain steps to enforce accountability in ways that don't involve disciplinary action, but there may be other ways.
But is there no duty on him as well to do the same? What I'm trying to say, Chair, is in this particular instances, because there are documents, signatures, memos, and so on, then we are able to take a particular action, or what is, there's investigations that are conducted, there are memos, there are minutes, and that. Then on the balance of probabilities, and then you say, yes, indeed, this did happen.
But you do know, Mr. Mokhesi, that it's going to be very rare for you, for somebody to reduce to writing an unlawful instruction that he knows to be unlawful. So you won't find a document. But does that mean that nothing will ever be done because
okay,
the other
let me
person...
talk about my personal experience.
No, let's not talk at the same time. I'll give you a chance.
Okay.
So does that mean that as long as the instructions are verbal, nothing will ever be done because there is nothing in writing?
But you must also live with the consequences.
Sorry?
You must also live with the consequences if you don't write.
Who are you looking at now when you say you must live with the
No,
consequences?
I'm saying if something is wrong and somebody instructs you to do something wrong, the duty is upon you to say, I'm not going to do it, or you raise issues and you advise. Right?
Yes.
It's
No.
on you.
I think that's understood.
If it continues, and there is an insistence as it is alleged here, right, then we have a record.
But are you saying as long as you don't have a record, then
It
nothing?
becomes extremely difficult as well. By the same way as it becomes very extremely difficult as well. Chairperson, also with those that report to me as well, I have instances where they also will write to me because I encourage them, because I also want to know why certain, if somebody along the line disagrees with a particular action, you don't simply say, I don't recommend, tell me why, so that I can also have the reason not to approve or to approve. Or instances, I can overrule that because I don't believe that you're correct, but it will be on record.
Mr. Pretorius?
Thank you, Chair. The point that is at issue at the moment, Mr. Mokhesi, is a broader point than simply your own knowledge and your own investigation, although your own knowledge and your own investigation is part of the point that I'm attempting to deal with you. At paragraph 93 of your own affidavit at page 127 of FS 14.
Where? Page?
FS 14, paragraph 127. That's your,
Oh, this one.
it's on the left-hand side. This is your affidavit.
You say paragraph, you say, Mr. President,
93 on page 127.
120 or 93. Yes.
You say,
Yes.
second colon, the department did not follow any proper procurement processes or process before concluding the material supply agreements. It simply concluded the agreements. It is unclear how it identified the material suppliers with whom it contracted. So you yourself in your affidavit at the time of this review identified the need to establish the really straightforward fact, it may not have a straightforward answer, and indeed it doesn't, that you've had a procurement process that was abandoned, you've had a second supplier agreement process where there was no procurement process at all, and out of nowhere or out of a database, people are just appointed in the discretion of obviously those persons who appointed it. So it would be important to know how those material suppliers were identified. Do you agree with that?
Yeah, but let's look at when was this affidavit made. It was made in 2016 and the people are no longer there.
No, but
Right. So in the process of, because where we started, advocate, we started with is it action proceedings? To try and get documents, because that was the key. Remember this, there were parallel investigation. SIU was doing something, was also busy investigating, but key to us in terms of priority was that let's know where the money is. We started with that action proceeding and indeed got a judgment before we went, because this was analyzed by a different advocate to say, no, I don't think this is the way that we should do, because let's do something, let's do this review application so that the honors fall on the other side. In other words, those who receive money must tell us, this is what we did with the money. If you can't account for what you have done with it, then it must come back. So this was actually the second part to say, let's review that particular decision.
I understand the point you make, Mr. Mokhesi, about lapse of time, but our investigators have managed to obtain at least some information in 2019 and 2020. It's not as if the information just disappears. The people are there, they can be asked questions.
No, but the people who were part or who were on this party are not there. I mean, those, I don't know whether you say they are there in terms in the department or elsewhere.
Well, they're
But
there.
you see, Mr. Mokhesi, for me, the later it is when you depose to this affidavit, the more time it means you have had to get to the bottom of everything and to get all the answers you wanted. If this thing happened in 2011, and you wanted answers maybe, and the financial year ended at the end of March 2011,
10-11.
and you wanted answers by end of April, somebody could say this time is just too short for us to do a proper and thorough investigation. So by end of April, you are not going to have answers to all the questions because more time is needed in order to give you answers to all the questions. We will give you answers to some of the questions, but not all the questions. But when you are talking 9 years later, 7 years later, if you had used the time available, you wanted to use the time to get answers, you have had all the time in the world. You don't have to investigate in 2016 when you are deposing to this affidavit. You should have investigated a number of years earlier and got all the answers to the questions that naturally arose in this matter. You understand my thinking?
No, I don't. I don't.
You don't understand
No,
that?
I don't understand where there's...
Okay, let me try and explain it again. If something happens today and you want to investigate it, and you say you want answers by end of today, that time might be too limited to allow a thorough investigation. If something happens today and you say you want answers by end of the week, it may be that that time is too short for you to get all the answers because the investigators would need more time. Okay? But if you say this thing that happened today must be investigated and you want answers in 7 months' time or at the end of the year, I'm saying the investigators will have had more time to investigate, and therefore chances that they will give you more answers to your questions or even all the answers to your questions are greater than when the time is shorter.
Chair, I think what is not appreciated here in this commission, one could have simply said, okay, the SIU is doing the investigation, there's a proclamation by the president, and leave everything to the SIU to do the investigations. But it seems that even that which we have done is not being appreciated. Obviously you are patching holes in terms of what we have done. Whereas I think, in my view, we have done sufficient within our means. We might not have done certain things, perhaps to say this is what we should have done, this and so on and so on. I think earlier on, Advocate Pretorius, when he started this thing, he said there was an overdose of the investigation, which is an indication of the number of investigations that were done, right? And to the best of my ability, I think I've done my part in terms of where we are right now, with two decisions in our favor And we are now in the position also to try and chase the money and get people to account. Now, the SIU also had played a specific role, and indeed we were sharing information in the process. You know, the only thing that perhaps I have not had sight of is actually the report. I saw the report now. It was attached, but as I've indicated, the report is not my report. It's the president's report.
Yeah. No. It's important that you put your side as to what you did, and if you believe you did it to the best of your ability, that's important. This is an inquiry. We are probing certain things, and the fact that you might not be able to answer a certain question is one thing, but we are probing to say, was this done? If it was not done, why was it not done? So you just answer to the best of your ability, and where you believe that you were not required to do more than what you did, feel free to say so. But we are probing to see what was done, what was not done, why was that not done, and you just answer. If you know why it was not done, you say, this is the reason why it was not done. And if it was done, you say it was done. If it was done by somebody else and not you, you believe somebody else did it, and this is who did it.
Yeah, but it seems as if I'm being taken on things that perhaps did not come to my mind on that particular time. Whereas, you know, and we are here and we are able to discuss this affidavit, which is the affidavit that was done at that particular. We are here and able to discuss that.
No, you see, Mr. Mokhesi, you are the current head of the department, or you followed after Mr. Mokoena. Is that right? Yeah. You followed after Mr. Mokoena. By reason of that, one would expect certain things, one would expect you to do certain things when you arrived at the department and found what you found. Okay? And okay. That has got to be looked into. Yours is to just answer to the best of your ability. There is no, it's not like if you say something and we are not happy with it, we are just going to accept it. That's not going to happen. It will be probed, and it's the right way that it should be probed. But from your side, feel free at all times to put your side of the story, so that when I look at all the facts, I will have your side of the story.
Noted, Chairperson.
Okay, all right. Mr. Pretorius.
And although some of the questions, Mr. Mokhesi, might seem probing and might seem to call you personally to account in your official capacity, really what the Commission is looking for is your assistance to help the Commission answer certain questions that it has. And the question that we're probing at the moment is the question of accountability. We know what happened to a degree, not in all the detail that we would wish, but to a degree we know what happened. And we're now exploring the issue of who was called to account for it. We know that a number of employees who participated in the execution of the scheme were dismissed, despite the fact that they said they were following orders. Right? And I'll deal with that in due course. There are two questions that do not seem to have been answered, let alone resulted in any accountability of note to date. And if we're wrong about that, then that's where we would like your assistance. The first question is, we know that there was no procurement process, either in respect of the contractors who built houses and in respect of the parties who supplied materials. But we know they were selected nevertheless. And the question is, who selected them and on what basis? And we would like your assistance in that regard. If there was no investigation done into that question, we would also like to know that, and perhaps even ask why not. The second question is this recovery plan or this prepayment plan, and in some contexts they treat it as different plans. Who devised that plan? Who is ultimately responsible and should be accountable for devising the plan and deciding on the plan in the first place? The very plan which employees then participated in to implement and got dismissed for. What has happened to that? Was that question investigated? So those are the sorts of things we're looking at now. And if I could take you to the findings of the disciplinary inquiry, because you referred to the disciplinary inquiry, at bundle FS 19, page 655. Page 655 of FS 19. This is an extract.
I'm not there. 655, you said.
Yes. Are you in FS 19?
Yes, FS 19. 655. 655.
Yes. This document is the reasons for the findings of the disciplinary inquiry into several employees who were charged and dismissed as a result. You know of those circumstances. Is that correct? Do you know who decided who should be charged?
Normally, what happens is that there will be first a preliminary investigation, which was done. I'll call it a high-level investigation, which was done by open waters to say, actually, can you look at this? What happened here?
Okay, I'm sorry. Just repeat your answer.
I'm saying normally, what will happen is that you look at, there will be an investigation. I will call it a preliminary to say we have this particular, and what actually happened here in this, and based on that particular recommendation, and then you will say, obviously, you write to those people and tell us why you should know, the normal part of leading to suspension, because then you have to look into their areas as well, them being the senior managers and in charge of that. And then once these people have been removed or suspended, then the investigation will continue in those particular areas. And ultimately, their role will then be determined. Their role in terms of all this particular irregular expenditure and so on will then be determined as to whether they should be charged or there's no, or simply won't be a warning and so on. And that process was done.
That's the general, that's your answer relates to the general. But Mr. Pretoria's question is specific.
I'm responding to what happened in this. It was through a recommendation in terms of the preliminary investigations as to who are the people who will have been involved in this particular advance payment or material supply, etc. So there would have been specific people who are in charge in those particular areas. And those are the people that we will look at.
So is your answer that you don't know in terms of names or who made the decision as to who should be charged,
No.
but there is a way of identifying who would have made a decision, who would have made that decision?
No, I don't say...
Because the question was, who made the decision as to who should be charged?
I made a decision
Yes.
based on the preliminary
Yes.
investigation about possible people who were being involved.
Okay, all right. So the answer, Mr. Proterius, is he made the decision.
Well, do you recall your answer earlier when I asked you, Mr. Mokhesi, about who devised the plan? Right? We know that employees were disciplined and dismissed for participating in the execution of the plan. We know that, correct?
Okay.
And in fact, I'll give you the detail in a moment from the finding. It's in the reference that we've just called up there. But I want to deal with one issue. When I asked you who devised the plan, you said as far as you knew, it was Mr. Nthimotse who devised the plan. And he did so in a memorandum, and we've got the memorandum, and we can show that to you in due course. But what is interesting is that persons were dismissed for participating in the execution of the plan. But to your knowledge, Mr. Nthimotse devised the plan, and he wasn't even charged. Can you explain that?
Mr. Nthimotse was not in the department any longer. He was a witness. He was a witness of in the disciplinary disciplinary hearing. So yes, he was not charged.
But surely it should have been a matter of course that if he moves to another department, he is charged. Nevertheless, you can't just escape liability for misconduct just by moving from one department to another, surely.
Well, he was not charged, Mr. Pretorius.
No, I'm just asking why? Why not?
Well, I don't have the reason, except that it was per recommendations. People were subjected to that, to say who must be charged and so on. And based on that recommendation from the investigations, the preliminary investigation, and that's the action that we took. Or that's the action that they took.
Well, would you accept at least the following proposition? Those persons responsible for devising and ordering the implementation of a fraudulent plan with all the characteristics that we've canvassed in evidence should have been held to account.
Yes.
Are you saying that at the time that you made the decision to go along with the recommendation to have certain people charged, at the time you made that decision, Mr. Toletse was no longer in the department?
Yes, he was no longer in the department.
Was he in another department within the same provincial government?
I think, yes, he was in agriculture. Yes.
Sorry?
He was in agriculture.
He was in agriculture.
Yes.
Did you ever bring to the attention of the HOD in agriculture or the MEC, did you ever bring to their attention the fact that here was somebody who had devised a plan that had caused the department to lose a lot of money that they may need to look into because you could not discipline him anymore? Did you bring that to the attention of his superiors in agriculture to say, the man that you have there used to be here, I would have charged him, I would have caused him to be charged with misconduct because we are charging people who were under him, junior ones, but he's gone, he's with you. But I want you to be aware of this so that he can be held to account.
Chair, some of these things as to who do you charge and so on, it will ordinarily be on recommendation. You know, I just don't choose to say that particular individual. Also take into consideration that Mr. Nthimotse was a witness in this, in the disciplinary.
Well, when you made the decision, he was not a witness yet, isn't it? He became a witness when the hearing started. When you made the decision.
The recommendations and the recommendations from the investigations was that these people are going to be the witnesses, and here are the participants, and so on. And this is how it went about.
But when any recommendation is made to you, including the recommendations that you are talking about, you are not meant to just rubber stamp, take them as they are, and make your decision on the basis of them. You are supposed to satisfy yourself that they are sound, isn't it?
Yes, which is what I did.
Yes. Now, the information placed before you, it seems, should have indicated that he was the person who devised the plan. Surely, if that's what the information before you showed, surely you should have been concerned to say, are we going to charge only the people who carried out the instruction and not charge the person behind the whole plan? Did you ask yourself that question? In other words,
okay,
it might be a wrong term, but the kingpin. How do we charge this? The real person who came up with this plan is the person who should be charged. How do we not charge him but charge the others who carried out his plan? Did you ask yourself that question?
Chair, maybe on hindsight, that should have been. But he was not in the department any longer. But I accept that perhaps maybe on hindsight, one should have taken it further than what was placed before me. Because you would hope at some times because this disciplinary process took a very long time. I think it took about 2-3 years to conclude, to say, as and when things are going, then some of the other things will come up. That's what we're hoping, because this was a very complex matter. It was not a very easy matter to deal with. And it still is a very complex matter, in my view.
So would you accept that you ought to have brought his role in this scheme or in this plan to the attention of his then superiors, namely in the Department of Agriculture, because it seems to me that a concern that you ought to have had would be, if this person could do this in my department, he could do that in another government department. They should at least know and see if they want to continue to employ a person who has played this role in this department, which belongs to the same provincial government. It's not another provincial government, it's the same provincial government. You accept that? Okay, Mr. Pretorius.
With this be a convenient time?
Yes, let's take the tea adjournment. We'll resume at 11:30. We adjourn.
All rise.
Okay. They reported May 20th. You give us all open waters does, but what open waters does is first almost all of them have a completion date. There is only a
So, John, can you get those 2 dates? Because I was going to ask, and I was going to say, we know what happened in agriculture. Stina happened after. The Stina time. Fine, thank you. I'm teaching, that's why I've got my mom. So please don't erase me. How are you? And how do you travel? Yeah. You live far away? Yeah, some transport.
So whenever I take it, no,
You know the answer. Both one and so I mean,
to avoid.
They moved at around this time, and we know what.
No, it's never been proved. I've interrogated it.
I know. Well,
Although I read in the newspaper that the IDC obtained an order in the US.
Thank you, Chair. Mr. Mokhesi, just for the record, our information is that Mr. Nthimotse and Ms. Dlamini, the CFO of Human Settlements, moved to agriculture and had moved by the time the disciplinary inquiry took place. Is that
Yes, correct.
And of course, we know that the MEC, Mr. Zwane, also moved from Human Settlements to agriculture at the same time.
Yes, correct.
And the activities that took place in the Department of Agriculture have also been the subject of this Commission's investigations and evidence, but we don't expect you to comment on that. Mr. Nthimotse's evidence, however, before the disciplinary inquiry is of some interest. If you would look at, please, at FS 13, bundle FS 13 at page 531. Yes, I'm corrected. I'm referring you to the transcript of Mr. Nthimotse's interview with the investigators.
Okay.
Page 531.
531. Yes, I'm on 531.
Now, his evidence was that he participated in the selection of contractors, and also that he had, through a trust, an interest in one of the contractors, which interestingly he didn't see as a conflict of interest, but that's not for you to account for at the moment. If one looks at page 531, at line 12, Mr. Nthimotse says...
Sorry, you say line 12, 531, FS 13.
Yes. You'll
I don't
see,
have
Mr.
line-
Nthimotse, it's actually line 11.
I don't even have 11, it's 10
You
and
have
20.
it?
It's 10 and 20.
Are you on
Unless
the
it-
black numbers?
Oh, okay. It's 10. Actually, for me, it's 10. 531 black numbers is actually 10.
Yes. Now I want to draw your attention to the next line, which is line 11. It's not marked,
Oh,
but
okay.
it's just the line after line 10. Mr. Nthimotse says, now, afterward this thing had happened, three things happened. I think it's December or January, that period. 2010, it actually would have been 2011. Yes, where I now moved to agriculture. And then he says, to get to move to agriculture, 5 of my colleagues get to be fired. That is now the 2010 onwards information. The HOD, Gift Mokoena, gets to be in the municipality, I think, Manguang. Where to now? Now those colleagues of mine that gets to be fired, a disciplinary hearing gets to be called. All what I have said here is what I have said in that meeting, to say there was a letter coming from the National Minister, the meeting of all of us was called to do a plan. All of us had the responsibility. And my responsibility was to produce those documents, and this is what had happened. So that is what had transpired. It's not very clear from what he said, but from what we know, he is saying that he, together with others, were visited with the responsibility of devising the plan and implementing the plan. Correct?
Yes,
And then Mr. Lamprecht, the investigator, says, why were they fired? Mr. Nthimotse, we were told that they were fired because of the solution in that disciplinary hearing. That is obviously the prepayment scheme, right? They were fired because of that solution. Mr. Nthimotse, yes, of me. Mr. Lamprecht, but you were never charged, that is the belief. And Mr. Nthimotse says, that is it now, that is what I am asked in that, and I hope it is recorded, he said. I said, I am coming here in this disciplinary hearing, and I'm asking myself why my colleagues are being charged, and I am not party to that charge. I am not being charged. I had asked that. Even, I think, they can say, because I do not know, I was not a witness for the department, neither was I a witness for them. I was just there to give what had happened to that, and I said that to them. So 2 points arise, Mr. Mokhesi. Firstly, that the information regarding Mr. Nthimotse's involvement was available at the time of the disciplinary inquiry. And the second is that even he was puzzled as to why he was not charged. Do you have any comment?
no, I don't have any comment.
All right. Let's look at the findings. Well, let me just put it to you. You know of the principle in labor law of selective dismissal, that it's unfair to select certain people who are guilty of the same conduct for dismissal and not to discipline others. That's unfair.
Well, you might
you know
confuse him, Mr. Pretorius, by referring to labor law. Maybe you should just put the proposition whether it's fair to charge some and not others if
Yes.
they've all done the same thing.
Well, perhaps I shouldn't have put a label to it because that's a specialist
Yeah.
endeavor, but it just seems in the first place unfair to charge those who were down the line in the pecking order, as it were, in executing the plan, and not charging the person who devised the plan on your version. That seems unfair.
He wants you to comment if you are able to comment on that proposition.
Oh, okay. I note that, Mr. Pretorius.
You don't want to comment on the fairness of that.
No,
even
I don't
even
want to
Mr.
comment.
Nthimotse commented on that.
Well, he was talking to other people. I note that. Thank you very much. I note, you know.
Would you not regard it as unfair if two people have done the same thing to charge one and not the other?
I would.
You would? Okay.
Yes. But there's another point I think that is perhaps more relevant for present purposes. And that is, instead of being held accountable, Mr. Nthimotse moves department and appears somehow to be protected against discipline. What do you say to that?
I don't know.
You don't know.
No, I don't know.
Well, let's look at the findings of that disciplinary inquiry, where Mr. Nthimotse actually testified, and so this evidence was available, obviously, when this testimony was given. At page 655 of FS 19, I'm going to ask you to change bundles, please, to bundle FS 19.
say page?
Page 655.
Oh, 655, yes. I'm on 655.
Do you recall evidence relating to the war room?
The war room. Yes.
Yes. You recall that?
Yes.
The war room was, in fact, not so much a room as a series of meetings that took place to devise and implement the prepayment plan. You recall that?
Recall that? Yes.
Yes. Please, if
Yes.
you would speak up, Mr. Nthimotse.
Sorry, I'm not Mr.
Sorry, not
Thomas.
Mr. My apologies, Mr. Mokhesi. Mr. Nthimotse and Ms. Dlamini both testified at the disciplinary inquiry. Now, we know that Ms. Dlamini was the chief financial officer of the Department of Human Settlements in 2010-2011. She moved to agriculture with Mr. Nthimotse under the leadership of the MEC, Mr. Zwane. Both of them testified in relation to the activities in the war room. Now, the employees were dismissed for, amongst other things, their participation in the deliberations at the war room. You know that?
Yes, I know that.
Paragraph 86, Mr. Nthimotse says, or not Mr. Nthimotse at this stage, this is the evidence summarized by Advocate van Graan, the chair of the disciplinary inquiry. And he's referring to the evidence of Mr. Nthimotse and Ms. Dlamini. He says in paragraph 86, as stated above, the MEC and the HOD created the war room. 5 of the employees, and they are then named, participated in the functions of the war room. So the first fact we have is this war room, which is specifically there to implement the plan for which the employees are dismissed, was created by the MEC and the HOD. That's Mr. Mokoena and Mr. Zwane, respectively. Paragraph 87. Mr. Nthimotse testified that the purpose of the war room was to create an intervention plan which had to be submitted to the minister. We've dealt with that in your evidence. Importantly, the next sentence, the parties, that's the department on the one hand, and that would have been under your watch, and the employees charged on the other hand, have agreed that the employees, that's the employees charged, have not participated in the decision to make advance payments to material suppliers. So the persons charged, it was common cause, had not participated in the decision to create and implement the plan. All they were involved in was, amongst other things, the discussions in the war room for which they were fired. Paragraph 88, Ms. Dlamini, the former CFO of Department of Health Settlements, Human Settlements, however testified that the war room, which was established after the formulation of the recovery plan, was to monitor the recovery plan. Paragraph 89, Mr. Nthimotse testified about the task of the war room. The war room meetings were usually chaired by the MEC. He specifically mentioned the presence of Mr. Ndenze at the war room, where the implementation of the new systems was dealt with. Then Nthimotse says, after the MEC would make allocations, appointment letters of contractors would go out, contracts would be signed, amendments were done. And then he refers to the sessions and the tripartite agreements. So what is apparent from the disciplinary proceedings is that the decisions at the highest level were made by the MEC and Mr. Nthimotse. Correct.
I see there's also a mention of Mr. Mokoena as well.
And of course, Mr. Mcquino, yes, we will speak to him later today, hopefully. But neither, it seems as far as our investigations have gone, neither Mr. Zwane, of course, couldn't be disciplined by you, he was an MEC, but nevertheless, Mr. Nthimotse or Mr. Mokoena were held to account in any way. Is that not strange? Do you
He's
have an
giving
answer?
you a chance to comment on the proposition.
To say, is it?
You say it is.
No, I appreciate and understand the concern of Mr. Pretorius to say,
Yes.
you know, I appreciate and understand. your
Strange, too
concern.
strong a conclusion to draw.
Yes. Do you also find it strange, or do you not find it strange?
Well, yes.
Thank you.
Let me ask this question. At some stage, did it appear to you that the then MEC, Mr. Zwane, might have played a role in this whole project that was not proper, not acceptable, or is that something that didn't appear to you to be the case?
Chairperson, you know, there's a reporting all the time for all of us HODs to MECs around, you know. They have their specific role that they play in the department, which is clearly defined by the law, and accounting officer also have. Now, with all these particular things that have been said there, if indeed it did happen, I'm not saying that it did, if indeed it did happen, one will conclude that there was an overstep by the MEC, if indeed this did happen. So, you know, that's my response to that if indeed this happened.
But with all the information that you were getting as the time went on, from the time you came to the department, did you not get at some stage, did you not reach the conclusion that maybe this was something, his role should be reported to the Premier?
Well, I have my MEC, remember?
Yes.
I would have my MEC who would also know about this particular, because this, you know, the disciplinary processes of the senior managers, because by law, the appointment of the SMS, as we refer to, you know, it rests with the executive authority, being the MEC. The MEC will certainly be knowing about what is going on. I mean, my MEC, basic.
Is your answer that you didn't consider that it was your role to bring to the attention of the Premier the role that MEC Zwane appears to have played in this whole thing, for him to decide what to do with the information?
No, it certainly is not my role to inform the Premier. My role is to have this information and also discuss it with the executive authority, who is the MEC, because I don't get into instances where I discuss directly issues with the Premier when I have the executive authority to do so, because that is a potential for conflict.
Yes. So you would have to discuss with your MEC.
Yes.
And then it would be up to him whether he took whatever information you
Whatever
got
information
to the Premier.
it
Is that
yes,
right?
Correct.
Yes. But did you discuss with your MEC the role that MEC Zwane seems to have played?
She will have the reports that are, around what has happened, even at the point of suspending, particularly if you are talking about senior managers. It has got to be in consultation. I don't know whether it's in consultation, after consultation, but I think you understand what I'm trying to say. Basically.
Yeah.
She will know. Probably not know on if it is lower than the senior managers.
Yes.
The director upwards, she will know.
Yes. Is your answer that you did not discuss these matters, MEC Zwane's role with your MEC as such, but there were reports had been placed before her, which if she read, she would have known what role MEC Zwane
Yes, the reports were there.
Yes. Okay.
In relation to the role played by the MEC, Mr. Zwane, Mr. Mokhesi, there will be evidence, not your evidence, that in fact he directed the creation and implementation of the plan. He participated directly. Are you able to confirm that?
No, I'm not able to confirm that. I don't know.
Let's get back, please, to complete that series of agreements. You will recall there was the first agreement with the contractors. You've described that to the chair. The second was the material supply agreement, the so-called tripartite agreement. You've described that. And then you went to some lengths in the affidavit, in the review application, to describe the material supply session agreements.
Are we going to hear back to his affidavit now?
Well, I'm going to deal in summary with that in order to avoid...
Must I keep this other file that
Yes,
we were
please.
dealing with just now, or it can come back later?
We will come... The disciplinary record, FS 19, we don't need that anymore for the present, please.
Okay. At some stage, Mr. Pretorius, you were referring to the findings made by the chairperson of the disciplinary inquiry.
Yes.
Did you get to them, or did I interrupt you and you ended up not getting to them?
The last paragraph I referred to was paragraph 89 on page 656 of FS 19.
Yes, I think you were, I got the impression you wanted to refer to a finding that might relate to Mr. Nthimotse, but I may have misread what you had in mind. As long as you have covered what you wanted to cover.
Yes, the passage that I was referring to was the passage testified to by Mr. Nthimotse that the MEC made allocations. And there will be further evidence, but that's to follow, Chair.
So we back to Mr. Mokhesi's affidavit at what page?
Yes. We're at page 98 of the bundle. That's bundle FS 14, paragraph 98, I'm sorry.
Okay. Paragraph 98,
Yes.
not page.
Not page, I apologize. Paragraph 98 on page 129 of FS 14.
I was wondering how we
One,
could
two,
go
nine.
back so to almost right at the beginning.
Well, we're going to go pretty fast now, Jim.
Yeah, okay.
One, two, nine.
Page 129. There you say in paragraph 98, the next piece of the puzzle is the conclusion of approximately 167 purported deeds of cession, termed material supply cession agreements by the contractors and material suppliers and agreed to by the defendant. Now, it's possible just for the record to summarize that by referring to the judgment of the court in that application at FS 14, page 603. And all I'm going to do is to ask you if you agree with that finding. It does appear to be consistent with your affidavit, but it will save us a lot of time.
603.
603, paragraph 13 of the judgment of Pohl AJ, POHL.
Yes, I'm on 603.
You have it.
Yeah, 600,
Correct.
603.
603, paragraph 13. The
Yes.
judge says, thirdly, there were the material supply cession agreements. The cession agreements purport, one, to give effect to a cession by the contractor as cedent of its claim against the department as debtor to the material supplier. If we could just pause there and explain. The contractor, the builder, has the duty to purchase and obtain the materials, and it then has a claim against the department,
Yes.
the client,
Yes.
for the material so supplied. And what was happening here is that claim was being handed, ceded to the supplier. Whether this was necessary or not, we'll come to in a moment.
Yes.
The second point made was that these agreements were intended to instruct the department to pay the claim to the material supplier on demand and not to the contractor. Correct?
Yes.
Because the claim had been now passed to the supplier. These cession agreements were then used as part of the documentation to create the farce of legitimacy so as to make the payments look regular and in accordance with the law. As indicated before, it was all done to circumvent the provisions of DORA, that's the Division of Revenue Act. Now, I can confidently say to you that these findings mirrored precisely the allegations in your founding affidavit. You accept that?
Yes, accept. Yes.
Yes. Of course, the reason for that is that it was entirely unnecessary to have a cession agreement other than to give it to the people who were paying the accounts in the Department of Human Settlements, to give it a veneer of legitimacy. Because when the materials, when the arrangement was made with the suppliers, there was no claim
Correct.
to cede because the house hadn't been built yet.
Yes.
And that claim would only arise when the house had been built, the foundation,
or the
walls, the
milestone.
roof. Correct.
Or the milestones.
The milestones, yes.
Yes.
When the milestones had been achieved
Completed.
and verified. Only then would such a claim arise.
Yes.
So it was entirely unnecessary to have these cession agreements other than to convince people to pay. Correct.
Yes.
If I could then go to back to your affidavit, please. At paragraph 107,
Page 107 or paragraph 107.
page 132, my apologies again, of FS 14. Paragraph 107.2. You're referring to the documents attached to your affidavit, and you say in paragraph 107.2, in NM 18, which is an example of a session agreement, the right ceded is supposedly the contractor's right to payment from the department in respect of the provision of bridging finance and or securities and the supply of financial services. This is frankly bizarre. The contractors did not provide bridging finance or securities or financial services to the department and had no claim against the department for payment of such services or products. Now we know that the description of the session agreement as being the cause of the session is described in some of the session agreements as being the provision of bridging finance and the supply of financial services. It seems that at that stage there was no understanding of what was happening. And in fact, you described it as bizarre because those services simply weren't provided. Correct?
Yes. And it's not, we are not in that business of bridging finance and...
Yeah. But it appears that what happened, and this is in the findings of the disciplinary inquiry, at least in some cases, is that money was being given to the suppliers, and the suppliers were then passing that money on to the contractors. Did you know of that?
Yes, yes, I know. There are instances where it was in the investigation, it was discovered exactly what you are saying. You know, money was paid to, and cash was advanced to the contractor for whatever reason.
So this is a way of spending a lot of money quickly, is simply to give it to the supplier, and the supplier then hands some of that in cash to the contractors. Completely illegitimate, I would assume.
Yes.
But that happened. Just for reference, Chair, those findings are in the disciplinary inquiry findings at FS 19, page 664, and FS 19, page 676. Perhaps for completeness we should go there.
Well, before you do that, Mr. Mokhesi, it seems quite clear from your paragraph 107.2 that what was being done was to make misrepresentations of facts in order to create the impression that there was entitlement to payment of money, or there was an obligation to pay money.
Yes, there was no cause for a claim.
And what these sessions were, it seems, intended to create the impression as if there was cause for payment.
Yes.
When actually there was no cause.
There was no cause for payment.
Yes. Yes, Mr. Pretorius.
Just deal with the first reference in the findings of the disciplinary inquiry proceedings at FS 19, page 664. Now, we know that Nurture, N-U-R-C-H-A, was one of the entities briefed to do investigations. You've said that to the chair, sorry. Page 662 of FS 19.
662.
Yeah, I'm on page 662.
662. This is a summary of the evidence of Mr. Lees, L-E-E-S, of Nurcha, N-U-R-C-H-A, which was an entity that was engaged to try and remedy the problems that had arisen in 2010, 2011. You've told the chair about that, correct?
Correct. Yes.
One of the things that Mr. Lee said appears in paragraph 108 on page 664. Mr. Lees established that some of the material... Do you have it?
Yeah, page 664.
664, paragraph 108 of
108,
the
yes.
disciplinary findings. Mr. Lees established that some of the material suppliers were advancing the contractor out of the session payments they had received for the material from DHS. So that appears to be confirmation of what you've told the chair, that suppliers would get money from the department and hand some of those monies on to the contractors, completely irregular, as you
Yes.
said. Correct. So your own conclusion at paragraph 109 is that the purpose of these session agreements was to enable the department to spend its money by making payments to the material suppliers. You say
Sorry,
that in paragraph
are we
109?
back on the same? On the,
Okay, I'm sorry, I'm taking it too fast. FS 14,
Are we
page
back on-
133.
on page 133, yes.
Page 109, the department then used the material supply session
Paragraph-
agreements to make
paragraph
payments to
109.
material suppliers.
Paragraph 109, you said page 109. I think
I?
that meant
Page-
paragraph.
Yes.
You actually said the opposite.
I
Yeah,
stand
page
corrected yet again.
133, paragraph 109.
109. Paragraph 109. You have it?
Yes, I have it.
So your conclusion there in the affidavit is the department then used the material supply session agreements to make payments to material suppliers. But what is interesting is the manner in which they were used, and you described that in paragraph 110. Mr. Mokhesi, you said, the material supply session agreements form part of the paperwork submitted to the department's accounting staff, together with an instruction to make payment. As I explained below, the department's instructions to make payment were accompanied by different documents from one case to another. In some cases, the department's scheme was completely crude, and in other cases, somewhat more sophisticated. But the starting point in almost every case was the material supply session agreement. And then you say, the material supply session agreement made it look as if there was indeed an amount due and payable by the department to the material supplier. You stand by that
Yes.
observation.
Yes.
Correct.
Yes.
And the reason is obvious, because the session hadn't created a claim in the first place. It was just used as a document to persuade the finance department to pay.
Yes.
Correct.
Correct.
In paragraph 114, you give an example of some of the corrupt activities that took place under the guise of the scheme. You say, moreover, many of such invoices are obviously false. Those are the invoices submitted as part of the claims. They reflect, for example, that material for roofs and walls had been delivered, but at such an early stage of the project, so soon after the conclusion of the construction agreement, that the contractor could have had no use yet for roofing and wall material, and had not claimed or purported to claim for foundation-related work or materials.
Yes.
Correct.
Yes.
So before the contractor, the construction entity, the builder, has even claimed for building the walls and the roofs, you already paid for the materials which by that stage would not have been delivered, correct?
Or the milestone, which does not exist.
I'm sorry?
The milestone, which does not exist.
Or the milestone had not been reached. And you make the point, of course, that the reason for this is that roofing material is the most expensive of all the material. And in that way, a lot of money could have been spent and received.
Yeah,
Correct.
in terms of the emphasis has always been on the, yes, the finishing part. It's
That's where the high costs
That's
are.
why the high cost is.
You make that point in paragraph 115 on page 134. In paragraph 118, and I'm not going to go into the detail of this, safe to say that the HSS, the housing subsidy system, has its own rules and regulations
Correct.
in regard to payment on milestones, correct?
Yes.
And that system was manipulated to put in their supply of materials as a milestone when it shouldn't have been, correct?
Yes, correct.
In paragraph 132,
One, 152.
132, paragraph
132.
132, page 143.
Okay.
You say that the department paid approximately 631 million rand without having received anything in exchange. There was no evidence when the department made its payments that it had received value for payments made in that houses had been built or part built to a satisfactory standard. Was that your information on your researches at the time?
That was
you
my
made this
information at the
affidavit?
time to say we did not, at that time, we did not receive value.
You did not receive value for money. You were satisfied with that statement at the time and
Yes.
now, correct?
Yes, because, yes, I think even for now, given what we have gone through and what is, the claims that we have against the supplier of material, I can only conclude that we did not receive full value. Amounts might have changed because there's been some recovery, I'm aware, by the SIU.
And then in paragraph 135, you make perhaps the most important point of this whole exercise. You say, aside from the issue of misspending of money, this scheme has had the result that many of the intended beneficiaries of the BNG project remained homeless. The department's flouting of national government's requirements, legislative provisions, ordinary prudent commercial practice and the like has had a practical consequence for hundreds of families. Their access to housing has been yet further delayed. Perhaps an obvious point, but worth emphasis nevertheless. You make that point.
Yes.
Then, paragraph 143 on page 147, if we could deal with that briefly, please. As I stated earlier, this is you speaking in the affidavit, Mr. Mokhesi, the department has instituted action proceedings against the contractors and suppliers. They are listed in the schedule attached as NM2.
Yes.
The first question is, was action taken against all the contractors and suppliers or only some?
To my best knowledge, it was taken against all the contractors and the suppliers.
Yes.
To the best of my knowledge.
There may be other evidence, or certainly a need for other investigation in that regard, but we do know that many of them had gone into liquidation or been sequestrated?
Yes, there are instances like that. Yes, there are instances like that where there were some that.
Have you got an estimate, maybe in your mind, of what percentage of the contractors and suppliers you are likely to get anything from? I mean, you said that all manner of contractors were put into the database, even those who were disqualified, some who had never built one RDP house were given a job to build 600 houses. In terms of their financial muscle, what are the chances that you are going to recover anything substantial from most of them?
I'm afraid from what I've observed, Chair, we might not recover much in terms of
Money.
my observation, particularly for those reasons that you have just indicated.
Yeah.
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 So, but we'll have to go on up to the end. You know, this process that has been where we have got by the court the latest application that we have done will continue against all of those. But clearly there are others who are liquidated that we know. And I'm informed that there's been also action that has been taken on other. I think our legal unit can be in the position perhaps just to give the latest report as to how far the process has gone and who is being.
The people who have been sued to try and recover money from, are they limited to the contractors and suppliers of material, or have you included officials and politicians who may have caused this situation by their conduct?
Well, let me to be fair also to the contractors, they did not receive, you know, when money went from the department out, it went to material suppliers.
Yes.
Right? And this is,
And it never got to the contractors.
it might have got to the contractors, as it has been demonstrated that there were some
Yeah.
instances where they were given cash,
Yes.
and in certain instances, the material was purportedly delivered, but there was no proof in a form of delivery notes, invoices, etc., that indeed that material was delivered. In certain instances, you have a delivery note, but then the contractor is saying, yeah, but this is not my signature. That is there. In certain instances, we have instances where we inform that material was simply dumped on site, where there were no people to receive it, and so on. Now, and I think this is also what informed the second review of, the review of the decision, to say to those that receive money, you must tell us what is it that you did. If you can't prove where the money went to, it must come back.
But my question is whether the department has also sued people who may have been in the department at
In the
time,
department.
in the
No.
department, including politicians, for their conduct that may have led to a lot of financial loss to the department.
No.
That has not been done.
No, that does not happen.
Has it been raised as something that should be looked into within the department or its lawyers?
No, it has
No.
not been. It has not been raised.
Okay, all right. Yes, Mr. Pretorius.
Thank you, Chair. Mr. Mokhesi, at page 150, well, perhaps before I ask you to deal with the matters that appear there, there have been indications, and I put it no higher than that for the present, that have been drawn to our attention by the investigators, that some of the suppliers and contractors who should have been sued were not sued. Do you know anything about that?
I've already said, to the best of my knowledge, all the contractors or material suppliers have been.
That may well be the subject of further investigations. But at that stage, I can put it no higher than that there are indications of that. If you would go, please, to page 150.
Yes, I'm at page 150.
150.
Oh, okay. Yes.
You deal there with the regulatory framework, and perhaps it's necessary to summarize that very briefly before we finish. You refer to the framework of legislation and regulations that were breached in this construction and supply agreement project. You start with the Constitution. We've dealt with that in evidence before. You deal with that on that page. On page 151, you deal with the Treasury regulations. And
151, okay.
the provisions of the Treasury regulations that are relevant and were offended, therefore the record, it is not necessary to go through them in detail unless you wish to, Chair. And then page 162, the department, of course, had its own supply chain management policy as it was obliged to have, correct?
Yes.
Paragraph 162. And
16.
of course, the
You
provisions
you
of
said
that
page
supply
162
chain management
initially.
policy were also offended.
Sorry, Mr. Pretorius, you said page 162.
No, page 152, paragraph 162.
Oh, I also thought you said page 162.
Yes, well, I'm
So
not
it's
reading.
152. 152.
152.
Page 152, para 162. I could easily have made another mistake.
Okay.
My apologies, Mr. Mokhesi. Para 162, you refer to the department's supply chain management policy, the provisions of which were also offended. Correct.
Correct.
And you make the point in paragraph 163 that there are very good reasons for the implementation of a fair, transparent, equitable, and competitive supply chain management policy. You say in 163.1, it's fair to do so, correct? And it helps reduce the corrupt award of government business. You make that point in 163.1. You see that?
Yes, I see that. Thank you.
It means, too, in 163.2, that if one complies with the procurement principles laid down in the law and the regulations and in your own policy, it gives people a fair opportunity to compete for what might be lucrative government business. And you make the point in paragraph 163.3 that the requirement of competitiveness, together with the more specific requirements of how bids must be evaluated and awarded, helps to ensure that government work is awarded to persons who are able to do the work. Correct?
Yes.
So if these procedures are not followed, not only is it unfair on people who wish to bid for the work and do not get the opportunity to do so, not only would it reduce corruption in the award of government business, but importantly, the process is there to ensure that people who are able to do the work get the work, correct?
Yes.
And you wouldn't have the problem of people walking off site or less problem of people walking off site, not completing buildings, which occurred in this case, correct?
Yes.
Then the provisions of, well, before we go there, paragraph 166, you say regarding the tripartite material supply agreements, there's no indication at all as to how the department identified the material suppliers. It is a gross example of the direct award of government business without a proper procurement process, made all the more flagrant by the fact that the department then paid substantial amounts of money to the suppliers and received nothing in exchange. Now that is an observation you made in order to obtain the order, as you've said, but nevertheless, I take it it's a correct observation as far as you're concerned.
Yes.
What it does indicate, however, it's the importance of conducting a thorough investigation as to how the material suppliers were identified. It's an important investigation, correct?
Yes.
Then on page 154, Mr. Mokhesi, you deal with the Division of Revenue Act. And the requirements of that act which we've canvassed. In paragraph 168.2.1 and paragraph 168.2.2, you deal with section 15.2C and B of the Division of Revenue Act, correct?
Yes.
And the reference that perhaps I should have put to you yesterday appears at the top of page 155. There, I'll read it to you. The section of DORA reads, in the case of an advance payment, 1, the receiving officer has certified to the National Treasury that the transfer is not an attempt to artificially inflate its spending estimates and that there are good reasons for the advance payment or transfer. And 2, the National Treasury has approved the advance payment or transfer. Now, you said yesterday that as far as you are aware, that approval could be presumed where a certain program had been followed, correct?
Yes. Correct.
And then in paragraph 170 to 171, you talk about the conclusions of unauthorized expenditure as well as irregular expenditure in terms of the Public Finance Management Act. We needn't go into detail there. And then interestingly, in paragraph 190.12, the then Premier and the MEC for Human Settlements called a meeting of senior department officials to discuss the fact that contractors appointed to construct the BNG-funded houses were simply not performing. Now, this is in 2012, in April. At that meeting, it emerged that the contractors' failure to perform under their contracts was largely caused by the fact that materials had not been delivered to them by the suppliers. We know that 600 million rand had been spent, approximately, the amounts vary, but over R500 million had been spent on suppliers, and yet in April 2012 there were still complaints of non-delivery, correct?
Yes. Correct.
And in paragraph 193 you refer to the fact that in fact the suppliers simply hadn't delivered material, or at least a significant number of them hadn't delivered material. Was that the finding?
Yes, that was the finding.
And then you talk in paragraph 194 of the department appointing Open Waters as forensic auditors to investigate certain of the allegations made by the contractors. Now, was that the contractors complaining that supplies had been paid for but not delivered?
Not delivered.
Is that correct?
Yes.
Just to summarize too, we have the nurture, NERCHA, remedial activity. They were appointed by the department, correct?
Yes, they were appointed by the department.
Yes. To do what?
In the main, to also to nurture, they are involved in project management and building and financing at the time, raising
Right.
finance. That's their mandate in the main. So they were assisting us, one, to reconcile and see what happened, and also to provide project management support to the department, which was obviously lacking.
Correct.
amongst
Then
others.
you've referred to the SIU report, Special Investigative Unit
Yes.
report. You've referred to the appointment of Open Waters as forensic auditors, correct?
Correct?
And you've referred to the disciplinary proceedings. All those reports and records, Chair, are part of the bundles and are summarized in the investigative report, which is before you. Mr. Mokhesi, you've assisted us with a great deal of information. Is there anything else that you feel you need to add?
No, I think, no, thank you, I have. It has been 2 long days.
Have you got any understanding why the criminal trials haven't taken place arising out of all the investigations that have been done? I see the disciplinary, the rulings, judgments in the disciplinary hearings, which were quite extensive and comprehensive, were completed in 2015. The SIU did its report. I think some people may have been charged at some stage, I'm not sure. Do you have any understanding, and simply because being head of department, you would have wanted to find out how the law enforcement agencies were progressing with their investigations, and they would have told you?
Chair, we had an understanding with SIU. And one of the things that they said that they would handle, because at some stage as well, I think they made me sign an affidavit. I suppose it was around the documents. I can't recall what exactly, because they did that on my behalf. That we will deal with the recovery part. They will deal with the investigation, because, you know, they are able to do certain things that we can't do. You know, they can access bank accounts of individuals and so on and so on. That they will look into that, they will make that investigation, and then hand over that information to appropriate law enforcement agency, whether it's Assessor for Forfeiture Unit, SARS, etc. So that was the understanding, and I'm informed that a case has been opened. I assumed that that was in that light, in that understanding that we had with them at the time.
How long ago was this understanding that?
Right at the beginning, when we made this, when we started.
Would that be about 2013, 14?
It will be around about 20. Already, by the way, they had already been, by the time I assumed office, the proclamation and so on had already been made.
Yes.
Already. They had already started, and hence also that my earliest thing to say, they were struggling to get information, but that's something that we have discussed. It's not for now. To say this is how we will proceed, and indeed we proceed around the civil route, because it was given the amount of money that went that I will say we did not receive value for.
Yeah.
It became important for the department to try and recover as much as possible, and the SIU will deal with these other issues. So there has been always cooperation between ourselves.
Yes. So nobody has been arrested or charged or anything?
Not to my
Not to your knowledge?
Not to my knowledge, but I'm aware that the law enforcement agencies are working on it. We
Yeah,
have
it's
been
just that-
interviewed by the law enforcement agencies.
It's just
as
that
well.
it's concerning because part of the complaints connected with allegations of state capture is that some of the law enforcement agencies were paralyzed or didn't do their job in regard to certain matters. Of course, it may be that in this case, they've done their job to the best of their ability, given whatever resources they have, and maybe given the enormity of the job, I don't know, but it is concerning when the taxpayers have lost as much money as we are talking about here, you know, and they lost it in 2010 and 2011. By the end of the financial year, 2010-2011 financial year, that is March 2011. Now that's close to 10 years, and no arrests, nobody charged, and yet the taxpayers, on your estimates at least, lost about 500 million rand or even more. And 10 years later, there is nothing that's the public knows, that the department knows, that gives confidence that something is being done, that the matter is being given the urgent attention it deserves. I mean, as I say, the disciplinary hearing seems to have elicited a lot of information and quite comprehensive. Your own affidavit was deposed to in December 2016, 2017, 2018, 2019, where next week we are going to be October 2020. That's about 4 years since your very comprehensive affidavit was given. And yet, nobody has been arrested, nobody has been charged. It is quite concerning. And of course, I've had evidence in relation to PRASA, for example, where also millions of rands were involved, where the chairperson of the board of PRASA at a certain time, Mr. Bobo Molefe, said, we presented all the evidence to the Hawks and asked them to investigate and take action, and they were not taking action. We had to go to court to get them to be forced to do their own job. And my information, if my memory serves me well, I haven't had any arrests connected with that or people being charged. And I'm sure there are many others. So it's very concerning. So that's why I was asking whether, as the HOD, you have been given any information that gives one confidence that maybe something is about to happen, because we are about 10 years after these things happened. But you have indicated what you have been told or what your understanding is. Okay, thank you very much, Mr. Mokhesi, for coming to give evidence. We appreciate it. I know that we are not seeing you for the last time because there is some evidence you still need to give in due course. But thank you very much. You are, I'm not getting any indication that your counsel wishes to re-examine you or anything.
No, No, nothing, Chair, thank you.
No, thank you, thank you. So you are excused, Mr. Mokhesi, thank you. Yes. Maybe we should just keep it, our resumption at 2.
As you please.
Yes. Okay, we'll take the lunch adjournment now and we'll resume at 2 o'clock. We adjourn.
All rise.